if I make a mistake? What if I don't have the warning on? What happens to me as a company, and how do you help me?
The way the process works is there is actually a cadre of plaintiffs' lawyers now. The who's in and who's out is constantly changing. Over the last 6 months to a year, there have been a number of new lawyers that have come into the process. But the lawyers know that if they go out, they investigate a product, they find a product, they bring it back, they get it tested. If they find one of the listed chemicals, their next step is to issue what's known as a 60-day notice of violation. That 60-day notice of violation basically puts the company on notice that there's a problem, that they believe that there's been a violation of the law. The notice also goes to the California Attorney General's office to give the California Attorney General's office notice of this as well. The Attorney General can take over the matter, but almost never does. And so then it reverts back to or stays with the original plaintiff who filed it. Their incentive for filing these actions are twofold. One is they can recover their attorney's fees, and that includes everything back from the time of the investigation, through the laboratory costs, through the time to put together the notice, to do everything else it takes to put a case together against you. So they immediately are due their attorney's fees, their reasonable attorney's fees. In addition to that, they're also entitled to keep 25% of whatever penalties are recovered, which is a different pot of money that usually ends up in a settlement. There may be 2 or 3 pots of money in a settlement. One is the attorney's fees, one is this penalty, and the other is what's known sometimes as a fee in lieu of penalty, which was the brainchild of some of the plaintiffs' attorneys to say, hey, this isn't a penalty, so I don't have to give 75% of it to the state, I can keep it all.
So the average member of the public thinks that the state is getting the benefit of this law and the public is getting the benefit, but in fact, it's really even more of a bounty hunter statute than people might think.
Yeah, I used to call it a cottage industry of plaintiffs that deal with this, but after having spoken with plaintiffs' counsel on a number of occasions, I now call it a mansion industry.
What are the products that you've dealt with in your practice where somebody claims that it wasn't warned on, violins? What are we talking about here?
Any product you can imagine. It's everything from cheap jewelry that may have lead in it, to food products, to food supplements, vitamins.
Okay, so how do they so let's say I'm a plaintiff's attorney. How do I get the information to bring the case, and then you're defending the company? What tools do you have to counteract what they do?
That's a good question. The statute is a very one-sided statute. Besides the automatic incentive that the plaintiffs will get their attorney's fees if they prevail, once they bring their action, or once they've perfected it and sent the notice to the Attorney General's office with supporting documentation to demonstrate they have an actual claim, the burden of proof switches to the defendant to prove that a warning was not required if a warning wasn't present. And that's a very high hurdle. It typically involves going to trial, after you have engaged experts to demonstrate and to prove, with a scientific certainty that there was an exposure that requires a warning. But in order to get to that point in trial is often usually a 7-figure sum of money, because you've got to hire the experts, got to go through the litigation. Plaintiffs' attorneys have been through this a number of times. They're really, really good at making the other side spend money. And eventually the company says, hey, if I can settle this for $50,000, why am I spending $1 million to defend it when I may not win anyway? So it's a tough proposition. So the plaintiffs do their job up front. Then when the notice comes out, it's on the defendant to prove they're innocent, if you will. So it's guilty until proven innocent. It really is that kind of statute. And it's a tough thing to do because it becomes a scientific issue.
Right, and so it turns on whether the chemical is present above the level
threshold
specified in the statute, and they come forward with some test result, and then you've got to rebut it.
Right. You actually touched on an important thing, because the level of chemical isn't always specified. Or the level of exposure isn't always specified. So that's another aspect that sometimes defendants have to work through, is to, with their experts, make a determination as to what level would require a warning, because it's not stated in the statute, it's not stated in the regulations. So just another area to waste money on in the litigation, which forces companies to settle. And the vast, vast majority of these cases end up settling. The tools that I use, I look at the company's background, I look at the company's history, I look at whether they've been in compliance or not. I look at what they do as soon as they get the notice of whether they come into compliance or not. Help them work through the system, work through whether or not they have competing test results that show that the product is compliant and does not require a warning, and we can use that to push back on the claim. But again, what we typically hear from plaintiff's attorney is, well, that's great, you've got your test results on that particular product, but I have my test results on this product, and this is the item that I'm claiming was in violation, not the one that you tested. And so then again, you've got competing test results, that puts you back into trial if you want to go down that road. And again, it's a losing proposition in most instances.
If you do come up with countervailing tests, that those are the kinds of things that you can make a judgment on, and you can advise somebody, look, it's worth getting this other test result so you can create leverage for a better settlement, or maybe you do want to take it to trial because you have so many other products coming down the pike. I mean, are those the kinds of things that as a lawyer you're helping guide them?
Yeah, exactly. One of our major cases right now involves, I can't go into the details of it, but it involves a claim where plaintiff's attorney says that there was a certain chemical in the product at a part per billion range. We went out, we've tested over 60 items. We haven't found the offending chemical in any of those items. And it's the kind of product that the company refuses and will not put a warning on, because this is not the product, but the example that I would use is, you won't put a warning on a pacifier because the warning would say something like, warning, cancer, reproductive harm, and you're not going to have your baby put that in their mouth.
Right. I mean, it's kind of funny because as Californians, we have warning fatigue. We're warned about everything, and so we tend to disregard the warnings. But when you get into something that's sensitive, a sensitive product or something that you really care about, maybe that you're putting inside your body, you would pay attention to that.